The Law Association says it has received a letter from the Attorney General seeking its comments on amendments to the Summary Court and Indictable Offences Preliminary Inquiries Act. The amendments seek to address the 53 matters which were left unfinished by Marcia Ayers-Caesar when she was promoted to a judge. More in this report.
To the letter dated July 20th sent to the Law Association, the bill seeks to expand the existing limited jurisdiction of the Director of Public Prosecutions to include instances where a presiding magistrate is unable to complete or continue a preliminary inquiry for any reason. According to the Attorney General Faris Al-Rawi, the bill also seeks to give power to another magistrate to hold a new preliminary inquiry or continue the preliminary inquiry in the interest of justice and with the consent of parties. CNews spoke with the Law Association President Douglas Mendes on this matter on Wednesday, and he said the body has to meet before making a comment.
The Law Association is currently considering the bill and will provide our comments to the Attorney General in due course.
He said this should be done before the middle of August. According to the AG, the bill does not need the support of the opposition to be passed if taken to the Parliament. However, opposition Senator and Attorney General Ramdeen believes legislative changes will not fix the problem.
If the Attorney General proceeds with this legislation, it will be subject to serious constitutional challenge in the court. It is clear that the government does not know what ought to be done in this particular scenario. We still have not been told, or we don't know as a society, what is the truth about the two versions that have been put forward by the Chief Magistrate and the Chief Justice with respect to how we found ourselves here. And it is very premature to take the position that the government has taken now.
He said before a solution is looked at, government must find the problem.
If the facts that have been presented by the Chief Magistrate are true, if the facts that are set out in her affidavit are true, and she was forced to resign, she has presented in her affidavit itself the solution to the problem. Because if she was forced to resign and she was properly appointed as a High Court judge, why do we need a legislative solution? If her story is truthful, then it may well be that she could be appointed as a High Court judge and be given the time to go and complete the part-heard matters.
The opposition senator maintained that government should consider setting up a tribunal to look into this matter as set out in Section 137 of the Constitution. Rishi Harinanan, CNews.